Hey Amir, can you station back here and admit people as needed into the waiting room?
Yeah.
Okay, where are you?
Should just
Here you
be. Yep.
Cool. Cute.
Um, you can make me an admin.
Oh yeah. You can also use my oops. Use that well.
Well, there are people playing anyway. I'm gonna turn my mic off too.
他们是在那里，在那个现场，不用现场也在讲。
Okay, says half a teaspoon. Maybe a little.
This surface is so pretty, like a tile.
Yeah,
Tiles.
or like granite.
Yeah, that's what I mean.
Yeah, and like tiles though.
Yeah, that's what it is. That's marble.
Yeah, love her.
You can make a necklace out of her.
Yeah.
Excuse me, can you mute yourself, please?
Oh my god. Sorry.
Thank you. Yeah.
Take knowledge of all lots of institutions very years. And yeah, it's a really exciting kind of thing. It's not a big boundary discussion. I think a lot of us have. So thank you for being able to share your knowledge with us. in addition to programs like this, we also have a shared studio. Where we are members, here, member, it's great. It's really nice to work. Like, it's kind of great. It's kind of programming. Involved in that in a normal basis. Oh, and also, if you're watching this on Zoom, can you indicate the chat if you can hear us okay?
And Max, make sure his mic is on.
Nice. All right. And then how do we turn, turn off the speaker though,
Oh,
so that we don't echo?
Yeah.
Okay. All right. It's because our
All right,
Our
so you
mic's
can-
on now.
People, you can hear us okay?
So much better, thank you.
Okay. You're welcome. Thanks for letting us know.
okay, good evening, everyone. Thank you so much, everyone, for coming. My name is Max.
I'm Cece and we are Studio Legal.
So we're a firm that works pretty much exclusively with creatives, creative entrepreneurs, so people starting small businesses, artists trying to represent themselves in their work across a variety of industries. And we thought it would be really fun to bring a talk like this to a wide group of people practicing in different areas and give a little bit of a primer on some of the key legal concepts we think will be useful to you in your practice.
Yeah, I think so Max and I met at like a corporate law firm and we had a lot of corporate clients and did a lot of like corporate stuff. And when we kind of went off to do our own thing, that's when we started working with like individuals. And it was kind of wild to me what individuals were dealing with. And then it came to like really onerous contract terms or like people who didn't quite understand what they had like entered into and were trying to fix it after the fact. So we really wanted to help the people that we care about the most, because even though we work so long for corporations, it turns out we don't actually love corporations, but we love creativity and we love the ability to help creative people continue being creative rather than be bogged down in all of the details. So that is why we're here today. And just to get a sense of what the audiences might be interested in. So I'm gonna ask, like, raise your hand if you're like the following type of creative person. So do we have any like visual artists in the room? Yeah, okay, a few. Nice.
You
Yeah.
could be more than one, too.
Yeah, you can be more than
You
one.
could be like an art director who also makes art.
Yeah,
you know.
it's not mutually exclusive. It's not an identity. So do we have any graphic designers? Okay, yes, several. How about any programmers?
Cool.
A couple. Musicians? Nice. Okay. Am I missing one?
Production, TV, film. Okay.
Cool.
And then I guess art direction, things like that. Okay, so good mix.
Yeah. All right, so let's get into the presentation. Okay, cool. So first, a disclaimer is that, well, we didn't actually hire a professional designer to help out with any of this. We didn't really want to waste their time, but it does mean that what you're seeing is made by us, and we're lawyers, not designers. So with that disclaimer, just, if it sucks, don't let us know. If it's awesome, please let us know. And here is an example of what you can expect. This is a drawing by me. So that's the level of art, guys.
So it wouldn't be a legal presentation without a reference to Elle Woods and Legally Blonde. But there's also some fine print that comes with the presentation. So this is really just for educational purposes only. It's not meant to be legal advice. We can't, represent you as lawyers in this presentation, but we would love to represent you as lawyers after the presentation. So if you liked it, if you want to chat with us, we're happy to speak with you and talk about any engagements down the road.
All right, so just a quick overview of what we'll be covering today. First, we'll kind of address one of like the preeminent questions, which is like, do I need to form a company? Like, what's an LLC? So we'll kind of walk through like the considerations for forming an LLC or a corporation and why we think you should definitely do that. And then we'll go through some copyright essentials, essentially like what it is, what it isn't, and what the internet likes to argue about what it is and isn't. And then we'll do some infringement do's and don'ts, just some guidelines so that you can create your work knowing that you aren't going to be slapped with like a cease and desist letter or a lawsuit. And then also some like things that you can definitely do to ensure that you can use the wealth of materials out in the world without fear. And then we'll go through the anatomy of a contract, which we'll try to make as least boring as possible, but we know that contracts are a little boring. And we'll finish with some hot topics where we'll cover things like personality rights and AI generated art. And we'll leave about like 15 minutes at the end so that you can like ask any questions. And like Max said, like feel free to jump in at any time throughout this presentation. We really want it to be kind of like more of a conversation and a discussion rather than just like us talking at you.
Okay, forming a company. So we get this question a lot, which is, hi, I'm, a photographer or I'm a designer and I'm operating on my own and my business has really started taking off. I don't have an LLC. I don't have a corporation. I'm just kind of doing it under my name. I'm maybe still working at another job or I just quit. I don't know whether I need to actually have an LLC, corporation, or other entity. So here's a couple examples that you're going to want to think about when you think about that question. So the first one, you can imagine a photographer on a shoot. The 20-year-old assistant is joining them. Really great. Everything's going well. And then the photo assistant slips on one of the props and sustains some injuries and requires physical therapy. You might have insurance coverage. You might not. It may not cover that amount anyways. You might have a limit on what it is that's covered, or you may not have insurance at all. So you're stuck with the bill and the costs of this accident. Here's another one. You're a website designer. You're doing some work for a really trendy cocktail brand. It's going really well. Everyone loves it. The website's looking great. The client's IT person warns you, hey, I think there might be something wrong with some of the code. It looks like it's revealing customer information. And you're like, oh, okay, that's really important. I'm going to write that down. I'm going to get to it. But in the rush of everything happening and in the launch, you forget to fix the code. So what happens? It's a month into their launch and they get a ransom demand from some unauthorized third party that says, hey, we stole a bunch of your customer information. Please pay us $1 million to get it back and so that we don't post it. And by the way, these are based on real life scenarios that Cece and I have actually had the misfortune of working through.
Yeah, we did a lot of privacy stuff, so dealt with a lot of ransomware attacks. And if you guys have heard about the MGM one in Vegas recently, where like no one could get cashed out of the, like they had to go around to the slot machines, like individually paying you out. And MGM just like lost millions and millions of dollars due to it. So it's not just a hypothetical, it's a real phenomenon.
And you don't have to be a big company. Like
yes.
This happens to big and small clients as well as big and small artists and operations. So the answer is yes, you do need an LLC or corporation or other entity. And the reason is that that's what allows you to separate your personal stuff, your personal money, your personal assets from your business ones. Okay, so when you create an LLC or a corporation, you're actually making another person. It really is recognized under the law as a completely separate person. And you're taking your business and you're putting it under the umbrella of that person and having them operate it and that company generate the assets so that it's all under that when something goes wrong. So that if something does go wrong and someone sues, it's after the corporation's assets, not after yours. There's some other benefits as well to think about. One of them is practicality. It's much easier to do accounting when you have two different when you have yourself and then you have your entity doing your business. It just makes it easier for keeping track of where money's coming in and where it's going. It's also great for opening a bank account. It's often very difficult to open up a bank account when you're operating on your own. It's much easier if you have an entity that you can go to the bank and say, this is my LLC, please open an account. And then there's some other considerations down the road that might matter a little bit less depending on what you're doing. But one of them is if you want to raise a lot of money, let's say you're a retail startup, you're thinking of selling cosmetics or something like that, you might want financing, meaning like you might want someone to invest in your company to give it the money it needs to grow. And for that, you really need a corporation. And there's also some tax benefits if you're really big, which is, and I should say on this one, we often get asked, okay, I'm a website designer and I have an LLC now. If I form an LLC, am I going to save on taxes? And the answer is actually no, because in most cases, you're really treated the same way as an individual as you would be in this corporate form. So that's not really always the best reason to incorporate, although it's often thought of as one of them.
Yeah, so at this point, you're like, all right, fine, I'll do an LLC or a corporation, but then also, what is the difference? So you'll hear these terms thrown around a lot, like LLC, corporation, and you'll probably see like people who say like blah, 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 corp or something, something Inc. And you're like, what is the difference? So Inc. and Corp are basically the same, but the two major type of business entities that you might be interested in are LLC and corporation. So for most creative businesses, just like across the board, I would suggest the LLC. It probably works for most creative businesses, but there are some certain considerations for a corporation that we'll get into. But the reason we suggest an LLC is because it has the most flexibility when it comes to everything. Like you can kind of change things afterwards. You can restructure it however you want. You can have like meetings. You don't have to really have meetings if it's just you. It's just easier to like be your own single member LLC. And for like my content creation stuff, I'm a single member LLC and it's really, really easy. A corporation on the other hand, like if you ever watch those shows and they're talking about like annual shareholder meetings, or you ever get those like letters or emails being like, hi, like you're an annual shareholder and like you're invited to this meeting. That's things that you actually have to do as a corporation under the SEC. So if you elect to do a corporation, then you're going to have to like do a lot of these like record keeping, have like a board of directors, have like meetings, have notes and all of that. And it's just like usually a bit too much. But I will say that if you want to get financing later, a lot of VCs, like investors, they will really only give money to a corporation. They won't give money to an LLC. And Max kind of mentioned the like pass-through taxation thing, which is why the LLC won't really save you taxes. Corporations might in the future, but usually you have to like make enough revenue, be pretty big and have a complex structure for that to kick in. So takeaway here is like probably LLC, but if you're hoping to get like VC funding or IPO in the future, then go for the corporation. Okay, so now you're like, okay, I picked LLC or corporation, but what state do I file it in? For the people sitting in this room, assuming you're from New York and you live in New York is the easiest answer for an LLC. It's usually where your operations are, where your headquarters are. It's just easiest for you to do wherever you are. If you are a corporation, the most common type of corporation will be in Delaware. And this is due to just like a lot of boring legal history about how Delaware has the most favorable corporate laws and blah, blah, blah. But it's gotten to the point where VCs mostly will not give money to you unless you're a Delaware C Corp, like this particular type. Like you might be like, oh, I'm like a New York corporation. They're like, no, we're going to need you to like change this in order for us to give you money. So if you're like looking ahead to that point, Delaware C Corp, get it out of the way right now. And also think about if you do business in other states like Nevada, Wyoming, you have to file for a business license in those states too, but it's pretty easy after you like do your initial incorporation. You can just file for as a foreign entity and it's pretty quick and easy. And you could be like, oh, but I also do business here. And don't try to get too clever. And like sometimes online, you'll see like a bunch of, oh, you can save taxes if you like form in Nevada or Wyoming, but it's like usually just like too complicated for most purposes. And you have to like pay for someone to receive your mail there. So essentially, If you're an LLC, do it where you live. And if you're a corporation, do it in Delaware.
What does doing business in another state?
Yeah, so that's a good question. So it really, states have like different rules depending on what what amounts to doing enough business. Usually it's like having headquarters or some kind of like physical location there, offices, or enough of sales there that you're really like targeting that state in some way. But if you just have like an online store and you do some sales to it, it usually doesn't qualify. Okay, so you'll also probably see a lot of like online filing services for LLC, like LegalZoom. I feel like we get a lot of questions about like, oh, okay, all right, can I just use LegalZoom? If you're a single member LLC and you're like, there's just me, I don't need to talk to anyone else about this. Yeah, kind of like you can use one of these like online filing services. They love this though. And the reason there are so many of these is because they upcharge you a ton. They probably charge you like 2,000 some for everything when it probably doesn't cost that much. And you could even really do it yourself, especially in New York. It's really easy to just go onto the website and file for an LLC yourself. But there are certain benefits to using a third party. And I went through this when I was forming my LLC. And I was like, you know what? I'm smart. I'm a lawyer. Like I can just file my own LLC. But it makes you put down your address and then you have to file it publicly with the state. And then these are public records that anyone can dig up. So if you're kind of like paranoid like me about people finding out your address, then maybe it is worth it to pay a third party filing service to file it for you. Or if you just look at the forms and you're like, I don't want to, like, I'd rather sleep. I'd like rather do anything else with my time. That's valid too, that like get someone else to do it, like use one of these filing services or reach out to us. And after you file for the LLC formation or corporation formation, they'll also probably try to upsell you on things like operating agreement and bylaws. If it is just you, it's probably okay because you can just change it anytime. You just ask yourself, hey, do I want to change things? And you're like, yeah, okay. And then you can just do it. But if you have other members or someone that you're going to business with, chances are the template operating agreements and bylaws they give you will not be sufficient. And that's when you really need to be able to consult someone else to help you figure out like what it should be. So don't click on that upsell at that point.
And to be clear, like for those of you who don't know bylaws, operating agreement, those are documents you have to have. If you're having a corporation or an LLC. So for LLC, it's operating agreement. For corporation, it's bylaws. It's the kind of rules of the road for how you manage the company. And an operating agreement is particularly important because it's really the only document that governs how the LLC is going to be structured and who's going to make decisions. So it's absolutely something you need to have. And one thing to keep in mind is if at any point you have more than one owner, right? That's why we keep saying single member LLC. So think about it this way. If you're going into this with someone else, if anybody else is getting a share of your LLC or your corporation, you really should consult a lawyer or get some advice on how to make sure that your documents align with your expectations. Because otherwise, you're going to file and only the person who filed is going to really own that company and have, you know, all of that.
Yeah.
If we file a single owner LLC now for this coming tax season, would you expect that LLC or is it like
You can put it in at any time because you can start taking business expenses even before you have an LLC.
Right.
Yeah.
It's just harder to keep track of. But if you're really good at receipts, yeah, you can just like, you know, count it as a business expense. It's just a personal
even
one.
like the fourth-
Yep.
Your business exists separately to your company. It's just that it attaches under the company at some point for the liability purposes. But your business continues before and after. It could be the same business. It just gets subsumed by the corporate.
Yeah.
Is one way to think about it.
Yeah. Like before the corporate entity, you're still a business.
Yeah.
You're just a business as yourself. But you can still like take all the tax things. It's just the legal implications are slightly different.
So this one's super important. It's not a guarantee and it's not automatic that you can separate liability of you from your business through forming a corporation or an LLC. You have to actually act that way in the world so that other people know that that's what you're doing. So one great example is for agreements. We see this all the time that a client will send us an agreement and say, hey, look, I got a new gig, like, can you look at this? And at the top, it'll say entered into between, and it'll be our client's name, not the LLC and not the corporation. it's actually a pretty big issue if that's the case. You really have to cross that out and correct it, because otherwise the contract is likely not entered into with your business. It's entered into with you. I mean, there's some ways that can be unwound, but you don't want to get complicated with this stuff. You want to keep it really simple. You want to have it be, if it's the business, then it's the LLC or the corporation signing. The other thing that's really important is about mixing, what we call commingling, the actual money and assets of the two. You want to keep the earnings and expenses separate for the business than from you, because you don't want someone to argue later, well, Max wasn't really operating under his LLC because he kept cashing the checks under his own name, and then he spent money out of that account, and it's all one account and it's all mixed in. So if I'm suing him for $25,000, I should have access to his assets too, because he didn't really treat them as two separate things. So it's really a performance to the world too of how you act when you run your LLC or corporation. So always try and keep that in mind.
Yeah, and it doesn't have to be perfect. You don't have to like do it all the time. The IRS kind of is like, like mostly, all right, we'll give that to you. Okay, so now we're gonna go through some copyright essentials. So first, what is copyright? I think the answer is right there in the name. It's the right to control copies of your work. So that's copying it, using the copies, modifying the copies, distributing the copies, putting them out there in the world. It's anything to do with this like work that is being copied. When the Copyright Act first came into, I guess, law, it was in 1790, and it only covered books, maps, and charts, because that's all we really had, I guess, in 1790. And it's only through expansion, through legislation later, that they're like, all right, photographs, we'll consider it copyrightable. And nowadays we have a lot of things that are copyrightable, right? We have, I think, music, Beyonce's album. We have visual art, Yayoi Kusama. We have movies and, I guess, soundtracks for 50 Shades of Grey, and the Barbie movie, including Barbie as a character. So these are all things that are copyrightable now and have copyrights. Our laws are so expansive now that about 8% of the US economy is due to copyright related stuff, like concerts, media, streaming, films, plays, all of that. So it's really a big part of our economy. And one of the reasons that I think the US is pretty strong when it comes to the arts is due to these copyright protections that our laws give, especially compared to some other countries. And one thing about copyright and why it is so powerful in the US is, if you're just like an individual author, the term of a copyright, the protection it gives you is your life plus 70 years. So that's like you, your kids, your grandkids, maybe your great grandkids. It like lasts for a really, really long time. One of the other things about copyright that I think is like important to know is that if you're just like, I don't know, having drinks with friends and you're like, oh, wouldn't that be a good idea? And then you like talk about an idea for a play or a script or something, that isn't protected. So copyright only protects the full expression of an idea, not the idea itself. So it has to have some kind of like written embodiment. It has to be like a script for the idea and just not the idea itself. And I think oftentimes, especially in our world of like TikTok remixes, we have a lot of people always being like, well, but like you stole that idea. And it's like, maybe they stole the idea, but you can't really steal a copyrightable idea in the US.
It's also, you think about like common tropes and stories, right? Like the sort of like Romeo and Juliet story, or the villain and the hero. Like these are all recycled ideas that are just ideas that get actually put into specific expressive works through an artist's hand. And so that's what becomes the copyrightable part. So let's talk a little bit about what is and isn't copyrightable. So some things on this slide are in fact copyrightable and some things are not. So the first one is the IKEA Billy bookshelf. Put up your hand if you think this is copyrightable. Okay, we got a few. So this is not copyrightable, most likely because it's mostly functional. So copyrights can't really exist in the functional aspects of the thing, even if it has a creative or expressive aspect to it. Only those little narrow creative expressive aspects can be covered by copyright. So there's probably nothing really in that anymore that's creative and expressive because it's a bookshelf and it's mostly just a functional object.
Is that a patent?
There are other ways to protect it. So there could be a design patent, there could be, yeah, mostly design patents. That's sort of what would happen in that world. But the truth is, in the industrial design, fashion, textile world, it's really hard and really thin. It's just, it's specific country by country, but in the US, it's really, really hard to get copyrights in those industries, as some of you who work in them. Yeah.
Okay.
Oh, sorry. Go ahead.
Oh, so yeah, I feel like those kinds of innovations in clothing usually goes under utility patents, so kind of like classic patents for inventions. And you'll see, I mean, I think like I was looking at Spanx's utility patents the other day. I'm like, Spanx has a ton of utility patents, guys. Like they are the forefront. So they'll probably file under utility patents. The nice thing about utility patents is that they do allow anyone who tries to use your thing, it like bars them from using the same technology, but it's only for 20 years and it can be pretty expensive to file for a utility patent. But yeah, if that is like something that you're like, I'm all about technological improvement, look to patents rather than copyright.
This one here, this is an interpretive dance performance. Who thinks that that can be copyrighted? Okay, so very few people. It can be. So an improvised dance performance can be copyrighted, but it has to be recorded in some way. So as Cece was saying earlier, it has to be in a fixed medium, right? So if I did a dance performance right now, assuming that camera wasn't on, you would all enjoy it and you would see it, but I have no copyright in that performance. So I can't stop anybody else from doing the same one in the future. But because it's recorded, I could point to the recording and say, this is my interpretive dance that I did. I own it. It's my creation. Don't copy it. Okay, Cece, you want to take that one?
Yeah, okay, so code, software code, copyrightable. Yeah, a lot of people. Yeah, okay, so you guys are right. It is technically copyrightable. But the issue that code runs into is that because code implements a series of ideas and modules, essentially, it's very easy for someone else to take your code, kind of tweak it a little bit, and then it still serves the same function. So you feel like they stole it, but if it's not the exact kind of line by line almost, then it's not considered a copyright violation. Yeah.
How different is it? Like, I just changed one line of code and I just take box or.
Yeah, no, so changing one line of code probably wouldn't be enough. So when it comes to copyright infringement, the threshold for whether it's a violation is called substantially similar. And if it sounds subjective to you, that's because it actually is very subjective. But yeah, like one line of code out of like a bunch, it probably is still substantially similar. And a lot of the fights in court are about what constitutes this like substantially similar line.
I mean, we're not going to get into it much in this presentation, but there's a whole world of like case law development around software code, because you can imagine all the big tech companies have litigated this. There's been some massive ones. And, there's different tests that get applied, like what parts of the code are functional. It's the same thing with the Billy Bookshop. What parts are functional versus expressive? And it's weird to think of code as expressive, but there's like filtration analyses. There's all kinds of things courts do, and they're very inconsistent. About what it is you can take and not take. And then there's all the open source issues as well, which is a whole nother thing, which is now there's all these licenses that actually allow people to use code, whether we think about the copyright aspects or not, but they have restrictions depending on the license. So, and that's a whole nother presentation we could give, one time. It gets very complex, but it's very interesting. Okay, the Nike slogan, just do it. Who thinks that one's copyrightable? Okay, interesting. Okay, so this is not copyrightable because it's a slogan. So it's a slogan, not
it's a sentence, and you can't actually copyright sentences. It has to be like larger than that.
So trademark, yes, but not copyright. So it's kind of like the question about utility patents. There's so many different ways to protect usage of something that might come out of creativity, but they all have different restrictions, different ways of getting them. Some are more expensive, some are for longer amounts of time. Copyright's a particularly generous one when it comes to time and ease of getting it, which is what makes them really attractive. And then how about this one here, this classic sponge cake recipe? Who thinks it's copyrightable? Okay, a few people. So it's not, because recipes, processes, know-how, none of these are copyrightable, which is kind of interesting because imagine you write a cookbook. It's true that the layout of all the recipes, the images, the text, the stories, that can all be copyrighted. But I could copy the recipes in a cookbook and redistribute just the recipes, probably without much, with impunity, really. So, I mean, don't do it. It is a big business. There's a whole like cookbook piracy business. But yeah.
I'm here. Yeah.
The slogan, I know it says it's not copyrightable, but put in Nike still technically pursues some kind of legal action against someone who might still utilize that slogan on there.
Yeah, under trademark. Yeah, so, but the thing with trademark is that you don't have a protection until you register it. So whereas copyright, you have the protection the moment you create it. So if you're like, oh, I want to use this phrase, you actually have to take steps to federally register it. And it's not until you get the trademark right that you can start using it. So it's, yeah.
Trademarks are much more complicated, more expensive.
Yeah.
So that would mean that like all these poor copywriters writing really amazing time, all of this like totally they're not going to trademark these like headlines or that valid or
Most likely, yes. Depending on like how wide of a slogan they're. I mean, remember that they all can form part of one work, that the work itself is valuable,
Yeah.
even if the title is not.
So yeah, it's kind of the sand heap problem. Like if you see 1 grain of sand, you're like, oh, it's a grain of sand. If you see 2 grains of sand, you're like, oh, it's 2 grains of sand. At some point though, you keep on adding grains of sand and it becomes a heap. The heap is protectable. This grain of sand isn't. And where that line is kind of like, I don't know, when do grains of sand become a heap?
So if I took the drip, like copied it word for word and I called it deploy, but it got really popular. Is there a tipping point where it's okay, sorry, we're now lost? Or if it, was kind of just cheeky and nobody cared, just fly right into the radar, would there actually be a point where somebody would say, wait a minute?
I think it depends on how much you copied from it. Is it just the recipes? Like, no,
Just the rest.
and you arranged it differently? Cheeky imagery. Yeah.
Well, and but that also could, I mean, that also starts to touch on parody and satire and stuff, which we'll also get to, but it's a really good question. I think it's a complex one because it's one of those things where if somebody did it, you'd find a million lawyers trying to come up with theories about why they could sue the other side. And then we suddenly have all kinds of intricate, so it's a good example, but not one I know we have a clear answer for.
All right, so one of the questions we get is like, do I need to put that like C in a circle on things? And the answer is no, not really, because you get a copyright the moment you make something. The moment you snap a photo, you get a copyright in it. You just don't register it necessarily.
so back to the dance.
Okay.
Yes.
Like on TikTok, all of those dances that you come up with, are they popular?
They aren't, but no,
Even the ones that are.
They're
like the TikTok dances or
whoever.
yes. Okay. So so this is a US Copyright Office policy. I think it's like vaguely classed as racist, but
Oh, like if it's
no. So the policy of the US Copyright Office is they do not allow copyrights for social dances. That's like their policy. So anything that's a social dance is not copyrightable, but if it's like ballet or like, some kind of, I don't know, modern dance. And as you can see, like the cultures which engage in social dances that are protected are kind of, communities which tend to be underrepresented. in things like that. So yeah, it's like a weird policy of copyright law that unfortunately does deprive a lot of people of their rights to profit from their creativity.
But if somebody was reciting a poem on TikTok, would
Yeah.
that be
Yes.
copyrighted?
Yes. So in the very early days, copyright, they were like, it only protects the fine arts. And in that is kind of a judgment call, right? About like class and what qualifies as fine arts. And this is kind of it's the downstream effects of that policy.
I don't really know how TikTok works. Is the fact that the video disappears
No.
affect the analysis?
No,
Does
it's
it say I recorded something and it was ephemeral. Do I only have copyright for the duration of the
No.
recording?
as long as it can be kind of like dug up again. And I'm sure they store things like that. If it exists at any moment in time and is documented, then it qualifies. So there's a lot of like sandcastle building contests, right? That exist. It's like thing, like you can have sandcastle building contests, and those are ultimately washed away by the ocean. But if you take a photo of it for that moment, like you can have a copyright in that sandcastle.
But I think it's an interesting question because to what effect, right? Like
Yeah.
if we can't dig it up, then probably no, there'd be huge issues. And if it's the sandcastle example, it's a little bit different because now it's like, well, what's the value of that copyright? I mean,
Yeah.
other than maybe I guess somebody, unless it's like an amazing sandcastle and something.
They're really amazing sandcastles.
Yes. See, this is where it gets tricky. Yeah.
I think what maybe like one thing you were alluding to, I remember like Fortnite had an issue that made her copy dances
Yes.
from like music videos.
Yes.
So
Yeah.
are there like other examples like that where there's gray areas of sort of dance or movement or
Yeah, so I think Fortnite is a good one where you can have your avatar like do these like dances, and some of them are taken from shows or TV things. But if they're short enough, I think the problem with TikTok dances is that they're all like 15 seconds or less. So it kind of doesn't qualify as this like fine art threshold that the copyright laws are protecting. Yeah.
Back to the example of reading off the poem on.
Yeah.
Is it the poem, the performance, or the video?
All. Yeah, so maybe let's.
If you took the video, I mean, if someone, it's kind of interesting. I mean, there's a question there about who owns copyright in the video, but yes, it would be all three.
You want to go?
Yeah. Okay. So this is kind of interesting. It's exactly that question. One work, many copyrights and owners. So think about an audiobook. You've got the person, so you've got Audible, let's say, who produces it and owns the recording. So they own the master of that recording. You've got the narrator who owns their own performance of it. So whoever narrated the voices, the characters. You have the writer who wrote the book that then was turned into the audiobook, who owns the underlying rights in the book itself. You have the songwriter who owns the musical composition. Then in music, copyrights are really interesting because you have multiple owners usually in the music industry, and the record label will own the music recording, so the actual master of the track. And then you have the visual artist who owns the cover art. All of these people own unique copyrights in the same art piece. So they don't joint own anything, they just individually own different pieces. And this can be reversed through agreements, which we'll talk about later. But look at this one, which is also interesting. This is one of my favorite art pieces ever, the Marina Abramović sitting still in the Artist is Present exhibit at MoMA. So this is a performance art piece. And this one's not the best example of joint ownership, but she did a lot of performances in her life that involved Ulay or another person pretty directly. And there's a strong argument that some of those performances are really joint owned, like the same work is owned by both people, which is different from the audio. And the thing and then there's also the videographer who might own the film recording itself, which goes back to the question about the videos. But joint ownership, which we'll talk about a bit later, it kind of sucks. As much as we love to think collaborations are really great, and collaborations are really, really great, it gets really, really messy when two people own the same copyright because they start to have overlapping rights in the same thing. And it means neither person necessarily will get the rights they need to grow their work. It happens a lot in anyways, it can be an issue.
Yeah, it's why a lot of, you hear a lot about artists disputing over things, and like when they're friends, it's like great and it's the best, but then they have like a fallout. Like I love the Call Her Daddy fallout drama when the two podcast hosts like had a falling out, and then they were like, but who gets to keep the IP? And that was like central to kind of their whole dispute. So even like being like, hey, like Max, you want to do a podcast together? You should get an agreement, because that is a setup for trouble.
Here's the rule, actually. Collab, contract, right? We're going to work together. We're going to do a contract together before we work together, because it really matters. We just represented recently, it was a design firm that did some design for a performance artist. And the two were so intricately intertwined that arguably it was really one art piece. Like sometimes it's quite separate. It could be like production design or whatever, but in this case, it really feels like both parties were coming and designing the same thing, which was this final performance art piece involving a bunch of objects. We got engaged to help them with this. And the first thing we did was we laid out all of the terms of who's going to own what. And it actually ended up being best for our client to assign all of their rights, because they were the designers, to the artist, so that the artist could grow the work, present the work, not have to get permissions. And what we did in exchange is we doubled their design. So it's just something really interesting to think about, which is collaborations and splitting up IP. It's not a bad thing. It can work out in your favor too. And sometimes it's better to have the party that has more of the direct interest in the work have control over the copyrights, because it just makes it work better for everybody.
Yeah, and like, if Max and I decided to start a podcast and we were joint authors, the default rules for like joint authors is that, he can do whatever with his right to it. So he can like license it to anyone. He can like sell it to anyone. And what if I end up like hating the person that he sells it to? I don't get to stop him from doing that. So these are kind of the default rules that you want, if you care about like who might become a joint author of your work in the future, you should really contract around. And a prime example is Taylor Swift.
Yeah.
So I'm sure you guys have seen a lot of like Taylor's version in parentheses after things. And she is a prime example of what happens when you just kind of enter into default rules for things and take what you can get. And it's not surprising, because when she got her first like record deal when she was 15, like, you're 15, you want to be famous, you want to be a singer-songwriter. I probably would have like signed anything. That makes a lot of sense. But she signed a 13-year deal with Big Machine Records. So from the ages of 15 to 28, anything she made, the master belonged to Big Machine Records. And during this time, she achieved like incredible amounts of success. So much so that she got into feud with Kim and Kanye, and it's like a whole shebang. And she really, really hated Scooter Braun, because Scooter was Kanye's manager at the time of their feud. And she really blamed Scooter Braun for kind of the social media harassment that she got from him and Justin Bieber, whom Scooter also represented. So in 2019, she found out that Scooter Braun, this man she despised, bought Big Machine Records and now owned all of her masters. It's like some person, I don't know, you're like high school enemy, all of a sudden owning this thing and profiting off of like your work. So she hated that. And then in 2020, Scooter Braun then sold it to a private equity company. So then like a private equity company owned her masters. And she was like so pissed about it that she was like, you know what, I'm just going to re-record everything. So I'll own my masters to Taylor's version, and that will be the version that I give to everyone and that I hope everyone uses instead. So this all could have really been prevented if she had a line in her contract about how before any sale or assignment of her masters, they had to seek consent from her first. But of course, she was 15. She like wanted to be famous so badly. Like we get why she didn't do it, but all of this feud could have been solved by one single line.
Should go to infringement. Yeah. We're going to skip some of these fun slides. Okay, so we're just kind of jumping to the next topic, which is infringement. We're jumping to infringement. So this is a photo that is actually of Blonded. Here's one of our clients and friends, taken by another client who's a photographer for her website. We did not ask her about using this photo. We have no permission to use it, and so we likely infringed it as part of putting it in this presentation. So we just wanted to go through, so when I say infringement, I mean you're copying somebody else's copyright. So you weren't allowed to do it, you used it, now what? Because we get this question a lot, which is, okay, so I had my image used or I used somebody else's, but what does it mean? Like, do I have to pay something? What happens? So these are our options.
Yeah, so first, I'm gonna go from, I guess, right to left. You can just ignore it and be like, you know what, it's not a big deal. Like, I don't really care right now, so I just won't do anything about it. Most people, I think, probably won't feel that way, but if you're like particularly zen, great. The second option is just like to reach out and politely ask them to take it down, kind of try to use diplomacy. The third option is when you send a demand letter, which is like the little scary cease and desist letters, and they're like very strongly worded, and then they're like, you know what, pay me, I don't know, $1,500 and I'll go away. And you can kind of agree to settle the issue. And then the nuclear option is really to file a lawsuit, which is basically saying I am willing to drag you into court, to drag myself into court, to resolve this issue because I'm so mad that you took my work, or maybe they're so mad that you took their work and they want to take you to court. So how many people think that suing is the right option? Okay, demand letter. Okay. A polite request.
Okay, some really nice people.
Yeah. Who would just ignore it?
Okay, really nice.
Yeah, it's a money issue, huh?
It's a great question, and that's kind of the driving factor here. So, and by the way, I should have clarified, it's Lainey who owns the image, not Blonded, obviously, because she's the one who took it. So it would be Lainey who's suing for infringement. But the reason that we would recommend polite request here is precisely that. So there's two types of damages that you can get in a copyright infringement action. And this is really, really fundamental and important for how things proceed. One of them is the actual damages. So damages meaning like what the loss was to the person. So in this case, the loss would be maybe like the lost license fee. So obviously, Lainey would have liked to have had us perhaps pay for the image to use it. And so maybe we don't know what that fee would have been, but probably would have been quite low for this kind of presentation. And then there's another type of damages, which is statutory damages. So these are created under the Copyright Act. And they basically say you're going to get at minimum $750 and up to $30,000 at the discretion of the court. So that leaves a wide variety of discretion and ambiguity here. And it kind of changes the way you think about it. And you can only get those damages if the work was registered. So remember we talked earlier about you don't need to register a copyright to get a copyright? Well, you do need to register a copyright if you want to sue for infringement. It has to have been timely registered if you want to get statutory damages. So there's a lot of details that we won't get into, but the point is that if you're in a situation where you use an image, you didn't have permission, and it was registered, you might be on the hook for more in an infringement action because they can opt for those statutory damages. It doesn't matter how low the license fee would, I mean, it does to a certain extent because they use that to calculate the statutory, but the point is that it could be much higher. And then reputation. It's why a lot of you raised your hands for polite requests. It's just good in these industries to let people know that you're nice and that you can, ask for these things politely.
So when that's that you register.
Really good question.
When you think it's something that other people will want to steal. So like you and your artistic discretion and judgment, you're like, you know what, I think this is something that other people might want to take. And it doesn't cost a lot to register something. Like I think for the easiest registration, it's like $45. So it doesn't cost a lot, but if you need to expedite it, it like costs more. If you need attorneys, then it costs more. But if you're like, oh, I think this is something that other people would want to take, then yeah, you should register that. And you can also do like bulk registrations. So if you're like a photographer and you took a lot and you're like, this whole series I feel like could be, is like other people might like, then you can kind of do like a bulk registration as well. Yeah.
Well, all about and media. So the party that kind of doesn't I think I often see a lot of people are showing that I don't know if there like a degree of involvement
so that's difficult. difficult. I feel like tagging the original creator is like you trying to be like, hey, this is like a fair use thing. I'm not trying to pass it off as my own. You're trying to give credit, but credit is a little slightly different than copyright infringement. I think it's kind of like the polite request thing where they're like, hey, you know, I'm giving you credit, so like don't come after me. But it doesn't completely absolve you of anything. Like if you copy it, and it just kind of like shows that you might be trying to use fair use as a defense. Like, oh, I'm like riffing off of you rather than I'm stealing from you.
Part of the but like for instance, like I'm relevant. I have like a part in photo shoots, for instance, but I don't take the photos. And like on my website that I use to demonstrate with other clients, oh, this is like some of my work. Is like what is the line of what I'm like allowed to use or what's like what I'm not allowed to post any of those things? Technically.
Are these are taken as part of like a job you've done?
Yes. Yeah.
So like
lots
it's
of jobs or like times I created or like.
So it's like, okay, so it's an example of, let's say it was in a film and the studio has a bunch of promotional materials that they took, and your production design stuff or costume stuff is in the promotional images for the studio. Yeah, technically no, but it's interesting because it's something you can negotiate potentially in your contract, your actual like freelance contract with them, where you could say, we do this all the time. Whenever we get a client contract that involves two people doing something with someone designing something for someone else, we always say we have the right to use any images you make from this project for our promotion, for our clients' promotional purposes. So that's something to think about. But the other thing is, the truth is, there's a lot of risk taking in these industries. And I was just talking about this the other day with a client. Like, a lot of people do use images from a job that they worked on without asking. And could it result in an infringement action? Yeah, but it often doesn't, because of the relationship the parties have anyways, and because of the type of usage not being inflammatory. So the legal answer is, yeah, it's probably infringement, but in practice, it might not be something that people care about.
Yeah. But if you guys ever have a falling out, that's when it opens you up to like potential issues.
So even though, I'm just sorry for
Yeah.
that, but even though like for an example, like a jacket I designed, it's like an image of the jacket that still doesn't belong to me, to somebody else.
Yeah, because for photographs, the copyright lies in whoever pressed the shutter. Yeah.
Even if you put that in your contract, or
It's-
different type of contract.
No, yeah, so that would mean that the photographer has the copyright, but they licensed it to you for use in like according to whatever your contract is. Yeah. So
We have like 5 minutes.
okay.
Do you want to do any contract stuff?
Yeah.
Sorry.
Wow.
We were so excited, you know.
I know we prepared so much.
These are all the things we could have covered. We can always cover it in another session. Okay, let's just talk about payment terms, because
Okay,
it's
yeah.
useful.
So kind of an example of how you can rewrite contracts so that they are better legally. So this is taken from an industrial design contract. So our client was a furniture maker, and they were making furniture for like their client who had commissioned the furniture, but their client was going to get the furniture made through a third-party fabricator. And initially they put that, you know, flat fee of $7,500, work to be billed as follows: upon commencement of work, $2,500, upon completion of design, $2,500, upon completion of fabrication, $2,500. So it sounds like, you know, it's fine. Like the total amount is the agreed amount, you know, there's like 3 stages, but there's a lot of ambiguity in what this means, right? Like commencement of work. When do you start work? Is it like when the designer puts to pen? Is it when they say like, oh, I started work? There's just like a lot of uncertainty about when that is. Upon completion of design. So like, when is it? Is it when the designer's like, okay, I'm done? Or is it when the client accepts the design, is like, okay, I like this design? You can kind of like argue back and forth about when that moment in time is. And upon completion of fabrication, this is based upon some third party acting and finishing their stuff. So what if like the fabricator just has an issue and like doesn't do something for 6 months? You're not going to get that last installment for 6 months. You're going to have to like chase this person and check in every, I don't know, month or so being like, hey, like just are we done yet? Are we done yet? So this leads to a lot of uncertainty about when you'll get paid. And I think as any creative knows, that certainty about when you get paid is really, really important so that you can continue running your own business. So this is how we would give it a makeover, a studio legal makeover.
It kind of looks the same. It's just like a bunch of text on the screen, but it's radically different. Just so you know.
It's legally beautiful. Yeah. But what we changed about it is we broke it up into $2,500 upon signing. Signing is a definitive event. You don't have to argue about like, oh, when did work begin? When did it end? It's just whenever you sign, whenever like two people have signed the contract. And then the remaining was due upon delivery of the design. So this doesn't attach the final parts of the payment to someone else. It just attaches it to you. And we also noted that, you know, design is defined elsewhere to limit the amounts of revision that they can ask for. So they can't just be like, you know what, for the 12th time, like, I don't like it. At some point, you have to stop and get paid. So these are all things that can be worked into a contract so that you have certainty about when you'll get your money and when they have kind of like used up their chances to get whatever they want from you.
And then I'll just say one last thing about contracts, and then I think we're at time. You can't get what you don't ask for. This is the most important thing, I think, with our clients and contracts that we have to say over and over and over and over again. There's nothing unreasonable about asking for changes to a contract. Like oftentimes we'll mark up a contract for a client and they'll be like, oh, there's a bunch of stuff in here. Like, I feel like they're gonna drop me for this gig, or I feel like they're just gonna not accept any of this stuff. Vast majority of the time, it goes to the other side. We don't hear from them for 2 weeks, and then they come back and accept 90% of it. And it's just the way that it is. Remember that on the other side, there's lawyers too, right? Like there's a lawyer at your client whose job it is to look at this stuff and come back with educated. And a lot of the time they mess it up. Like the other side is just, you know, whatever team was dealing with your contract and they missed something you talked about. And otherwise it would have not been in the final agreement and it would have made no sense. And, you know, it's also just about tone, right? Like, look at this sentence here. We use it all the time. Thank you so much for sending this over. I just have a few cleanup changes to make sure this reflects our agreement. Somebody reading that, they're not even going to look at your changes half the time. They're just going to be like, oh yeah, okay, yeah, I guess this was just like something we had to do. All right, and then they sign off on it. So can't guarantee that'll happen every time, but it actually does more than you think. So advocate for yourself, make changes. It's fine.
Yeah.
What is contract legally binding? Like the example of
Yep. Yeah, you don't need a lawyer to have a contract. In fact, if it is just like you and your friend, you're like, yo, let's start a podcast, write it on a piece of napkin, like, and then just like sign it. That's all you really need. It's just when two people agree on something is when a contract is formed. Yeah. And yeah. Oh, okay. Yeah, and I think, you know, to emphasize this point is the initial terms that you'll see for a lot of things will be very scary and will be very unfavorable to you. But it doesn't mean that they won't accept revisions to that. Oftentimes they will, because I mean, my default contracts for a lot of things I know are like very favorable to me because I'd kind of be dumb to not try that, right? But it does, but if people push back, I'm like, yeah, you know, you're right. Like, let's just change it. And I think that's true for a lot of the people that you're contracting with. As a first like default, they'll make it way good for them, but they don't really care. They want it to be fair too. It's just, they're going to try to take as much as they can.
Okay, is that it?
Yeah.
We should, I mean, we can open it up to Ellie. Is it questions now?
Sure, whatever you guys want.
Okay. Unless you want to hear, do you want to? You can take that.
Yeah. Do you guys, unless you guys want to hear about the AI stuff. Cool. Okay.
You want, yeah?
Okay, cool.
great.
Yeah, so AI generated art, it's something that we've seen a lot of, and this is actually completely made and named by a computer, Davis. But it's this like beautiful work called A Recent Entrance to Paradise.
Just kind of beautiful.
Yeah, it is very beautiful. And Peter Thaler, he tried to register the copyright in this creation on behalf of the computer. The US Copyright Office was like, no, only humans can get copyrights. And now they're kind of appealing the decision through the courts. The general rule of thumb is that if an AI makes it, non-humans cannot own the copyright. But then you're like, okay, well, maybe I can own the copyright that the AI made. And then, so about a year ago, this woman, Chris Koshtanova, she made a graphic novel with Midjourney, which is like an AI generated software. They make like art, and they actually did receive a copyright for the comic book. However, then the Copyright Office found out that they actually used Midjourney to create a lot of it, and they revoked a lot of their copyright registration. What happened was the Copyright Office was essentially like, you know, you can own the text and the positioning of the elements, but if you didn't make the actual art, then you can't get a copyright in this. Later on, they did release a policy statement in like March of this year that it's a really evolving field. They don't quite know what to do about AI generated art, so it's a little up in the air. But they're saying that like if you gave a prompt and the AI generated the art, there's still not enough direction. You need like a lot of human control over the AI. Whereas if you think it in your head and then somehow you can have more control over what the AI outputs at the end, they said, yeah, maybe we'll consider that to be copyrightable. But as it stands, like Midjourney, not copyrightable, DALL-E, not copyrightable. But as AI maybe gets a little bit more specific to actually embody what you have in your head, there is a possibility that in the future we will see AI generated art have copyrights awarded to their human owners. Oh, yes.
So something that I do, I like writing to ideas and I made this reference. And so then taking the reference imagery and using that as a reference instead of like, but sometimes it's like, I'll literally just redraw what I'm seeing, but in my own state using my style and having other elements. So what I create then is the most derived or like reference to Midjourney. That would still be
Probably, yeah.
right?
Yeah, you would have a copyright in your work that you drew.
Yeah, you're good.
You would have to show what you changed, and you would probably.
We're trying to questions in the chat. Can you ask that again? I'm sorry. What if you modified it? The AI generated art for a certain percentage? I guess you want to do it.
Yeah, and then the Copyright Office might be like, all right, so you have a copyright in the 20% that you changed.
It's being tested. It's one of those areas where there actually probably isn't a direct answer because we're waiting for people to challenge these things and courts to decide on them. Whereas like all the other topics we covered, you know, there's years of examples. Like, but you can imagine 40 years ago or whatever, maybe the interpretive dance question was totally up in the air, but it's kind of like that. We really don't know. It's a really good question. It's interesting to see how it will evolve.
Yeah, so actually, I think OpenAI is being sued by artists on this very issue. There is like no settled law on it, because if you're an artist, you're a human, you like look at 50 paintings and then you just like come up with your own. That's clearly you're not copying them for the most part, but there is like a difference when the AI is like crawling the internet and absorbing all of it. So it's emergent case law. We don't know yet. They are litigating it in court. We'll see.
Yeah, there's a lot of interesting examples of that.
Yeah.
So if I would take, for example, like a Ellsworth pyramid shape, right? And I made that out of brick or plastic or another shape. Would that be safe then and market that product, or like how I could like a shape, like a distinctive shape would be like how safe am I, like, how much have I changed the vision for?
Oh, should we go to the substantial
Yeah,
similarity
I'm
slides?
sorry.
We didn't, it's a really good question. We didn't cover this, but these are some really interesting examples of that.
Yeah, so
Right.
so this is a photograph on the left, and on the right is a Jeff Koons sculpture based off of the photograph. Jeff Koons ended up being found to have infringed the photograph's
This was
copyright.
different.
Yeah, because it wasn't different enough and they looked too similar. And he did just make it a 3D version of this 2D photograph.
And then,
And then, yeah, similar thing happened with Rihanna's music video for S&M, where on the left is a David LaChapelle photograph that he made. It's called like Striped Face. And then on the right, there's a scene in the music video that's in this like pink striped room. And the judge was like, you know what, there are differences, but I could see someone thinking that like these were related and you took from it.
Yeah.
So, David LaChapelle sued and they were going to go to trial, but then they settled. So if you if you do it in a different medium, there is still like precedent that there is some danger there.
So it's up to like the judge to say like, oh, it's different.
Yeah,
and they go both ways. Like sometimes it's mystifying, and there's also the purpose, right? Like you said, and commercialize it.
Yeah.
I think in your question,
Right.
makes it much harder because we didn't talk about this, but there's certain permissible uses that are leaning more towards art, criticism, education. Like even this presentation we're doing now, it's educational, so likely not infringing anyone's work. So it really depends on what you're doing.
Okay.
Yeah, is there like along the lines of that, is there a strategy to find the judge who is sympathetic?
Litigators do that to a certain extent. I mean, you can't really, but like there's they do like make their arguments satisfy the particular personality of the judge.
Yeah, but no, your case just gets assigned to a judge. You can't game the system there.
So educational purposes are sort of detached from like printing a photo in an art book or something like that would be.
Because that's commercialized.
Because an art book is commercial, but like teaching it in a class, like if you're like, oh yeah, like or like even a pamphlet booklet to class, and you're like, this is in the context of a university. The fair use, yeah. So for fair use, it's essentially like, yes, I did copy, but here's an out. I'm using it for criticism, comment, news reporting, teaching, scholarship, and research. If you're using it for those purposes, and if you don't make money off of it, then you're like very clearly, squarely in fair use territory. But the moment you start like deviating from that very pure example, that's when you start getting into the gray area, and like they could have an argument, and do they have more money than you? Then
but
you set yourself up.
To be honest, we were kind of shocked that this past semester, like it really is all over the map, and it's cultural and it's time specific. Like this happened in the 90s, 2000s. It shifts depending on the decision maker, as you were saying. It shifts depending on what we think culturally. Like the recent Andy Warhol decision was kind of surprising to a lot of people.
Yeah.
Like this didn't make it across the line. They focused a lot on the fact that it was also being used for commercial purposes in a magazine, like licensed for a magazine cover. So the message here is, if you're going to start getting dangerous with copying other people's work as part of your art,
and you want to say it's fair use, and I know so many people on the internet are always like, it's fair use. Fair use is very subjective. It's like hard to rely on. It could be very expensive for you to rely on. So if you're like fair use or the highway, you really should consult a lawyer first to see if that's even holds water, because fair use is kind of very, very subjective. And it's more like, does this particular judge or jury want this thing in the world? Do they think they want this more than they don't want it? Yeah, it really depends on the court. So the court isn't technically supposed to like really care about public opinion, but if these cases go to juries, juries are very like susceptible to public opinion. So you're kind of rolling the dice and just trying to see what goes on.
I think this is answered by image up here, but somebody in the chat is asking, can you, is a drawing of a photograph copyright infringement?
Yeah.
Yes.
Yeah.
Yeah. All right.
I think is that.
Yeah.
I mean, I would stay for another 2 hours and talk about all these things, but I sense like, some people want to leave and then like other people want to ask questions. So maybe we can stick around a little bit, or we can go somewhere else too and keep
After
talking.
party.
Yeah, we can after law party. Thank you very much. Thank you so much. It was really, really great. Oh, that's a good question. Studiolegal.xyz. And both our emails are on there. It's just max@studiolegal.xyz and CC, or hello@studiolegal.xyz is on there. I have cards too. I think CC does too. We're happy to give them to anyone who wants them. And we usually, like, if you want to call us and chat about something you think might be an engagement, but you're not sure, we always do that on a complimentary basis. We just chat and see if it's a fit, see if there's anything we can help you with, and then we would decide next steps. So don't be intimidated by that. If there's something that's really on your mind, you can reach out. Yeah, studiolegal.xyz. One word, studiolegal.xyz.
Another cool membership benefit at Index that we're working on is hosting these two for office hours. So they'll post up, and if you're a member at our space, you can come and talk to them about your legal woes. We don't have a contract yet, so no collaboration without contract, but
We like that approach. The truth is, we're probably not going to sign a contract for this, because we say to sign contracts, but then we freewheel it all.
Thanks for coming. Thanks everyone. Thank you.
if you got a glass from us, you can put it back on the bar.
We didn't really, I was excited.